Hello everyone. Thank you for joining us for the session and welcome to LexTalk World Web Conference. I welcome all the attendees and thanks again, to all of them for joining us for the session. And let me first of all formally introduce myself. My name is Sagar. I'm the host for the session today. And today's topic is protection of data and privacy rules. To talk about this wonderful topic, we have a wonderful session indeed. We have a wonderful panel indeed with us, and I would love to introduce you to all of them one by one. We have Beatriz Ruiz-Beato. She is the Data Protection Officer, NEC Europe Limited from Spain. We have Letícia Baddauy with us. She is the founder partner of Baddauy Advocacia, Brazil. Then we have Syed Belal with us. He is the Director of Cybersecurity Consulting from Hexagon PPM from Bahrain. We also have Mr. Syed S.U.Khan. He is the partner in S.U.Khan Associates, and he's also corporate legal consultant in Pakistan. We also will be having one more panelist joining us very soon, Mr. Sébastien Christophe. He's the Data Privacy Officer in Royal Bank of Canada. He's right now in Singapore. So he'll be also joining us for the session. But meanwhile, I welcome everyone. Thank you, everyone, for joining us for this session. And I now hold this baton to Mr. Syed S.U.Khan. He is the moderator for the session. Over to you, Mr. Khan.
Thank you. Thank you, Sagar. And a very warm good evening or good afternoon, wherever you are. And thank you for your kind introduction and nice words. So at this point in time, when in 2016, GDPR was formulated and in 2018, it was implemented across Europe. I think now 3 years from 2018, it's a good time to discuss about the legal framework concerning personal data protection. Europe has already done and has implemented the law, and many of the countries, like I'll be speaking about later in my part, many of the countries are under the process to develop these laws on personal data protection or the legal framework to secure and to protect the privacy and the personal data of the individuals. So it's a very good time, and I'm grateful for the ClickAway creators that they have provided this opportunity for all of us to share our knowledge and our discussion. And it is very unique experience to listen and talk about the same topic with people sitting in different parts of the world, Europe and Bahrain and Pakistan like this, and in Singapore, our colleague Sébastien is there. So without putting much time of my audience, I will request Ms. Beatriz to start her talks. She will basically be discussing about recent personal data breaches in Europe. She will also talk about the risk assessment and data protection impact assessments of the GDPR, and finally about the complexity of international data transfers. Just for a note purposes, the questions our audience, our attendees will be putting, and they will be put forward towards the end of the session. Please.
Yeah, thank you so much. Good morning, good afternoon. Well, I would like to thank you, all of you, for being there, listening us today. I will be focused on Europe, as I have great panelists to discuss the rest of the globe. And having a brief introduction, was the GDPR considered the new golden standard among data protection regulations? Well, to me, as a European lawyer and data protection officer, I think that every day more and more information is created, captured, and stored in digital systems across the globe. And in response to that explosion, the European Union need to do something in these regards, and they introduced the GDPR. The GDPR, as all of you are aware, and I'm not going to get through, it's designed to protect individuals, to prevent some privacy risks, and to control, data processing activities. Can we say that it's enough? Having you a clear response, I would say no, having in mind that the European has already started the discussions about the GDPR in 2012, and the GDPR was really effective on 2016. So the GDPR born old-fashioned, and the GDPR didn't cover all privacy matters so far. But let's be positive, because the GDPR had also good points. Yeah, the GDPR harmonized laws across Europe, and they created and defined a EU standard applicable to all business and public organizations. That it's also clear that the extraterritorial scope of the GDPR also put many other companies outside of Europe which are subject to the GDPR. And on the last years, some international companies were considered the GDPR as a default position. Having in mind the situation that we are dealing so far, well, the GDPR, as I really mentioned at the beginning, came to force in 2018, and we have seen that many other countries are evolving new data protection laws. So we will discuss and debate all together if it's really the new standard gold on privacy matters. Having in mind this and moving to one of the challenges, I would like to start with the data breaches. I think this is one of the trends of 2021, and that it's clear that in November 2021, the number of data breaches happened during this year has already exceeded the total number of data breaches in 2020, sorry. So, and this trend is expected to continue. To give you numbers, an estimated 80% of data breaches in 2021 involved a human element. Phishing is one of the top threats actions that result in a breach. The number of breaches that involve ransomware has doubled. More than 60% of the breaches involve credentials, and over 80% of breaches were discovered by external parties. So we see every day in the news information with regards to new data breaches. But having in mind what I highlighted, I would like to mention 4 data breaches that happened between June and October this year, to see what are the type of data breaches that Europe are really suffering at this moment. The first one, it's in France. Hackers stole personal data of around 1.4 million people who took COVID tests in the Paris region. So hackers were hacked the public hospital systems in France. The other one that I would like to highlight to you, it's the Italian Society of Publishers and Authors. They were fallen victim to a ransomware attack. This society requires authors to verify their identity, to provide tax information, as well as health insurance details, besides of collecting contact details. So I think that this incident was really attracted for the public scrutiny, as we were talking about individuals who are in the entertainment, musical, and theater sector. And by the way, the supervisory authority in Italy is still investigating this case, but what is clear is that that personal data is already in the dark web, for sale. Another case, it's not Europe, but it's okay. It's UK. The top secret Ministry of Defense documents were found in a bus stop in Kent. Those documents reveal information on the British military strategy. And the last one, it's coming for Mercedes-Benz, a vendor of this company informed that personal data of certain customers and potential buyers were exposed due to non-secure cloud storage instance. So with those examples, I would like to highlight that you can see the trend. It's more focused on security, cyber attacks, and the COVID situation, it's already impacted in the European business.
Thank you, Beatriz. You have thrown a very good highlight and insightful statistical information on the breaches, and also a brief particulars of the last 4 important breaches. So would you like to continue more about your discussion point of complexity of international data transfers and about risk assessments and the data protection impact assessments?
Yeah.
Okay. Before Beatriz continues, I'm really sorry to interrupt it this way. We have Sébastien joining us for the session. So I want everyone to to know him personally now. So thank you, first of all, thank you very much, Mr. Sébastien, for joining us. I know you have been facing a sort of issues in joining us for the session, but I appreciate you being here as a panelist. So I welcome Sébastien. Sébastien Christophe is the Data Privacy Officer of Royal Bank of Canada, Singapore. And he is going to give some more insights on the topic that we are discussing today, which is already in continuation, that's protection of data and privacy rules. So over to Beatriz again, and Sébastien, Mr. Hasan, Mr. Khan will be taking care of all the discussions now from here. I am right here waiting for all the questionnaires. So thank you very much for guys joining us, and please continue the discussion. I'm really sorry. Thank you very much.
Thank you, Sergey, for introducing Mrs. Sébastien. Beatriz, please carry on.
Yeah, I will continue. So let's go to the other challenge that European business is suffering. Data protection impact assessments. At the end, it's all about identifying and minimize risks, associated with the processing of personal data. Data protection impact assessments are useful for ensuring the efficiency, cost effectiveness, and of the security measures that all companies need to be implemented on certain type of processing activities. It's a risk-based approach, which means that this document or this exercise will ensure companies don't waste time or resources attempting to mitigate risks or threats that are unlikely to occur or will have limited impact. Also, data protection impact assessments support our GDPR accountability principle. Will be able to prove that companies are in compliance with the regulation, and of course will give trust to our customers and vendors. Challenge part of the data protection impact assessment is that we all need to complete and conduct this exercise at earlier possible. I think that if you do this exercise at the beginning of any project, we can incorporate it and embed the privacy principles from the beginning. And it is all linked with the data, the privacy by design approach, that many companies in Europe are still identifying what it means, and which are the benefits. But summarizing to you, I would say that it could be improved or reduced potential problems if we do this exercise at the beginning. Also, from a cost point of view, if we address problems early, will be easier to solve and cheaper for companies. Awareness of privacy and data protection will be also increased across the organizations and business. We were less likely to breach the GDPR. And of course, this exercise will help companies to provoke negative impacts on individuals. Sometimes we lost the track that this exercise has to be done in order to protect individuals. It's not something that covers companies. So I think it's also important to highlight having in mind the data protection risk assessments. I'm not going to cover when do we need to do the data protection impact assessments. It's Article 35 of the GDPR. But I would like to highlight when we conduct the DPA, the three aspects which are more relevant. The first one is assess, necessity, and proportionality. I think that it's important to consider what are the purpose that you would like to achieve, and if you can have the same result in another different way. Another thing that it's also important to consider are the lawful process, the basis. We need to have a proper legal basis for each processing activity. We will need to provide data subjects the right information. We need to be much more transparent. We will be able to exercise individual rights. And we need to ensure that companies also take into consideration measures with regards to data processors. The other part that I consider essential is identify and assess risks. As I mentioned before, thinking always in individuals, not on companies. We need to assess if there could be impact on any financial loss, or we can produce any economic disadvantage. Also, if we are restricting any services to individuals, or even though if that processing activity can have an impact on their social situation. Also, data breaches, if there can be any illegitimate access to personal data, or that processing activity can provoke even a loss or modification of their personal data. With that information, we will be able to identify which are the likelihood and severity of those privacy risks. And if companies, right, could fall within acceptable levels. If not, we need to do an internal exercise, in order to identify if somehow we can mitigate those privacy risks for individuals. And there are many security measures, organizational measures, also measures to put in place with data processors for not losing track of the individual rights and freedoms. But it's so challenging for companies doing this exercise, having in mind the context and the global environment that we are living so far. So now we are in Europe, but I don't know, my cloud provider can be in US. So these are complicated more and more, this kind of exercise in order to comply with the GDPR requirements. And having in mind what I have already highlighted, let's go to the complexity that Europe is right now suffering with regards to international data transfers. As you know, last year we have the Schrems 2 situation to challenge our databases. The European Tribunal Court decided to, well, to invalidate it, the EU and US Privacy Shield, because, well, they considered that the US was not ensuring or giving us the same level as in Europe. And what is the most significant impact on the SREMS 2 situation? It's even though the Tribunal European Court decision didn't invalid standard contractor clauses, because they were mentioned that companies would continue to use the standard contractor clauses. In order to use it, the data exporter and data importer must verify that there is no reason to believe that any laws or practices applicable to data importers hinders the data importer in fulfilling its obligations under the SECs. And that is the complexity. I think that the European Commission has put burden and administrative items to companies to assess the surveillance and security laws of third parties that mostly European lawyers are not aware of. So that's my first comment with regards to this, having in mind that it was completely unclear and uncertainty for business in Europe. The European Supervisory Board launched several recommendations in order to help companies to have a look to the extra and supplementary measures that we will need to put in place, yeah, in order to protect individual rights. And, well, as I mentioned, they are recommendations. They are not binding documents, but that would help companies to understand what we need to have into consideration when we need to do a transfer impact assessment. Moving on this topic, on June, we received the new gift, the new standard contractor clauses. We were waiting for them, right? And that would be great. They were modular, more flexible. I think that they would cover many situations, to data controller, controller to processor, processor to processor, yeah, processor to data controller. So I think that from that point, I think that companies in Europe, or even not in Europe, yeah, due to the extraterritorial scope, are more happy, yeah, are more confident that we are protecting individual rights. But my last comment with regards to the standard contractual clauses is that even though the new ones have already covered many SREMS 2 guidelines, the truth is that the new standard contractual clauses are not covered all. So that means that the data transfer impact assessment has to be managed. And again, having in mind that we are in a digital transformation world, global environments, it's getting harder and harder to get that data transfer impact assessment for certain companies. So of course, that is my opinion, yeah. I will leave for a debate with all of you. Thank you.
Thank you, Beatriz. I really appreciate it. You have very rightly and very elaborately covered the pros and cons of the data protection impact assessment, and I really appreciate your concern that data protection impact assessment is individual centered. It's not the company based. It is to protect the rights and the privacy rights, the fundamental, I would say, fundamental privacy rights of the individuals. And you have touched upon also about the EU-US privacy shield and the new standard contextual clauses. I agree with your point that the new clauses even do not cover the full scope of the subject matter. But as a lawyer, we understand that each law or the regulation will have got or develop jurisprudence or the maturity with the passage of time. So by the time they will come before the courts or the tribunals, these standard contractual clauses or other provision will got matured and have a more developed consensus all over the jurisdiction. Again, thank you very much for your insightful opinions, and we respect your opinion. And you were the first to open the chat or the discussion this evening. Thank you very much.
Thank you.
Thank you. So now moving on, acting today or this afternoon, like as a moderator of this session, I'll be discussing in Pakistan. We have not introduced the law on personal data protection, but our government is in the process to develop this law. So I'll be discussing the salient features of the upcoming law in Pakistan and what is the role of the government of Pakistan to develop this law or to have developed this law. And thirdly, I will be discussing what challenges we foresee. The law is not there, but what challenges we see in implementation of this law, the upcoming law. So as a background information, our Ministry of Information Technology is charged with to develop the law on this subject. And in early 2020, in April 2020, they issued a draft law, a draft bill. And it goes to so many sessions, consultation session. It was the ministry consulted so many stakeholders, public sector, private sector, international organizations, civil service organizations, civil society organizations. And thereafter, in this year, in the month of August 2021, they issued another improved draft based upon the consultation they have from the last year till August of this year. So now this draft law has been finalized by the Ministry of Information Technology. And as per the procedure, it is now sent to the law ministry, because the law ministry has to vet this law in accordance to the legal parameters. And thereafter, this bill will be tabled for the approval of our federal cabinet. And thereafter, it will go to the legislature for making it into a law. The proposed law, the name of the proposed law in Pakistan is Personal Data Protection Bill 2021. And it is mostly based upon the GDPR model, and it's a right-based approach. I mean to say that this law confers heavy rights on the data subjects to protect their privacy and to protect their personal data. So in a nutshell, the law covers almost all the parameters or all the model or the theoretical aspects of the GDPR by giving heavy rights to the national persons or the individuals. Importantly, one similarity I would like to point out that which we have seen in the case of GDPR, as the GDPR text was approved in 2016, but it was given 2 years grace period time till May 2018 to implement the law. Likewise, the draft bill in Pakistan gives a 2 years grace period, so that in meantime, the data subjects, the data controller, and the public sector authority who has to implement this law has ample time to familiarize and get themselves prepared for the upcoming law. So this is again the similarity between GDPR and the upcoming Pakistan law. Then again, the law is centered between three parties as a law for the GDPR. It's one, the data subject, very important element of a triangle. At the one side, it is a data subject. On the other side, there is a data controller or the data processor. And other side, the public sector regulatory authority. In Europe or in the GDPR, it is known as the public sector supervisory authority. The name or the proposed name in the upcoming law is National Commission for Personal Data Protection of Pakistan. For rest of my discussion, I'll be referring to it as a commission, the Pakistan Commission, for ease of understanding. So the data subject, data controller, and the National Commission makes a triangle to implement, to enforce this law. As I already mentioned, that the proposed law is a right-based law, and it confers almost all the rights which we can see to all the rights to the national person, the data subjects, which are available in many jurisdictions covering this similar law, including the GDPR. And just to point out, we have the right to access, right to rectify, right to withdraw the consent, right to prevent the processing, right to erase it, right to data portability, and the right not to subject to the automated profiling and the decision solely based on the automatic processing. Again, when it comes to the obligations, the basic principle which a data controller or a data, for that matter, data processor is to follow are the same which we can see in GDPR and so many other laws. These are three principles: the lawful purpose, the purpose limitation, and the data minimization. So our law is based, the draft law, I would say, is based on these three principles of lawful purpose, purpose limitation, and also the data minimization. Again, the consent has got a very importance and very significant value in the whole structure of the proposed law. And the consent is one of the major requirements that data controller can process the data with the consent of the data subject. Then notice giving requirements are also there, that whenever a data controller have to process or to collect the data from an individual or the data subject, he has to give him notice that I'm getting your data. It will be used for this purpose. I'll be sharing with third parties or not sharing. What are your rights and what are your, if in case of any complaint, how you can raise your complaints. Again, for the data breaches, the data controller is required to notify the data breach again within 72 hours to the authority, the National Commission, and also to the data subjects. And of course, the National Commission, which will be established by the federal government after the coming into law, this National Commission will be making security standards to be followed by the data controllers in order to protect the security of the personal data. And the law says, or the draft law says, that these security measures or security standards will be based on best international practices. And I believe our commission will inspire the already established or the practice examples from other jurisdictions to make the or to prescribe the security standards. The commission, which I said that the commission, the National Commission of Personal Data Protection, will be established by the federal government after the law is in force. It will be having huge powers and excessive powers to implement, to enforce, to administer all the laws, all this law. And they will be, in addition, they will handling the complaint or the grievance settlements, and also will be imposing penalties. Likewise, in GDPR, we have the corporate penalty, but it's little less than the GDPR standard. It's 1% of the annual turnover or 30 million Pak rupees, whichever is higher. And when we say 30 million Pak rupees, it comes to about 180,000 US dollars. So my next topic will be, before switching to my next discussion topic, which is about the challenges that we can foresee, I would just like to highlight the role of the government of Pakistan and especially the Ministry of Information Technology in developing this law. As I stated earlier, that Ministry of Information Technology put a very aggressive and a consultative approach. I would say a constructive consultation approach. They have consulted more than 100 consultation sessions have been done to listen to the different stakeholders, their concerns, and to incorporate their concerns into the law. Now the present draft of the law has adequately considered the points of the concern raised by different stakeholders, by the banks, by the telecom companies, by the non-profit organization, and so many other institutions, even the foreign companies also. And they have adequately considered and put in these amendments into the previous draft, and the present draft is now in a much improved form. And more importantly, the present draft, which is now gone to the Law Ministry for vetting purpose, is based on the a larger understanding or the consensus of the major stakeholders who are going to affect by this law. So when we come to challenges, So as I said, as by now all of my participants or the audience have known that at the moment there is no law in Pakistan for data protection, personal data protection. But I feel that the biggest challenge would be to make awareness to the national persons, individuals, that now this is law. If you have some data breaches, so these rights are available to a national person, to a common man, so he can knock the doors of authorities that my data is breached. I would here like to use an example of the consumer protection laws. We have in Pakistan consumer protection laws, both at the federal level and also the provincial level, say 30 years back. But unfortunately, the consumer protection law has not been so matured for the single reason that our consumers or the common man has no awareness that the law is there, and within law he has got massive rights to go against their suppliers or the vendors. The commission, as I said, the National Commission for Protection of Data, Personal Data, will be established by the federal government, and among many other functions, it has a function to promote awareness of personal data protection. So we believe that once the commission established, among other things, our other governance and the lawmaking or the rule-making exercise, it will promote or create awareness session among the general public so that this challenge can be, because at the end of the day, the purpose of these all legal framework across the globe is to protect the privacy and the personal data of the national person, which we say data subject. So I hope the National Commission will do a lot of good exercise to make a good awareness campaign all across the Pakistan so that the real fruit of this law can be derived. When we come to next, the challenge will be to the data controllers. What challenge they have? They have to make a capacity building of their own team, because the data protection law by its design is not only confined to the IT department of a company or to a legal department of the company. HR, finance, administration, every production department, because everyone is now dealing with the personal data of their vendors, applicants, third parties, so many things. So they have to do a data protection impact assessment. They might have, under certain conditions, have to appoint data protection officers. But the improved sector or the already regulated sector, for example, telecom, the banking, the listed companies, or the companies who are covered under the Code of Corporate Governance, they are already accustomed to comply with so many rules and regulations. So it would not be a very big challenge for a big companies like that. But yes, it will be really a big challenge to implement this law in true spirit by small and medium enterprises, because they don't have so much resources in terms of money terms, and also in terms of available resources. Law is equally applicable to all size, all kinds of companies. So real challenge will be for the SMEs. And again, I believe that the trade bodies and the like chambers of commerce here will do their exercise. Whenever in Pakistan in the past some business related law is there, then Chamber of Commerce and some other institutions like our own firm, we also doing some awareness campaigns and the sessions, in particular with the public sector and also with the private sector. So the awareness concept for this, or the facilitation, I would say, the facilitation part is very necessary for the SMEs, so that they can aware what their obligations are under the upcoming law and what are the means and sources, so that they can comply with this all compliance level. Then lastly, I will say, I will discuss very briefly, because the National Commission, I say its name is National Commission for Protection of Personal Data of Pakistan. It will be a new organization in Pakistan. So it has its own challenges, not only in terms of its own governance, but the law is made, it's a supreme law, or it is a primary law, which is made by the legislation of Pakistan, which is National Assembly and the Senate of Pakistan. The subordinate legislation, which we say as rules and regulations, are the responsibility this National Commission has the responsibility to make the subordinate rules and regulations. For example, the compliance framework, for example, the data protection impact assessment framework, for example, the appointment of data protection officer framework, and more importantly, the security measures. So the second challenge will be that this National Commission for Protection of Personal Data has to frame these all framework, rules and regulation in a timely manner, so that sooner the law is implemented, each data controller or the data processor should know what rules I have to follow, what standard I have to follow. So a timely making, and again, this rule making exercise will also be required to be a consultation based, so that there will be no new surprise or some so much cumbersome requirements which may not be able to fulfilled by many of them. My colleague Beatriz had covered about the international transfer or the cross-border transfer of data. So I just in a very small way or in a very small means, I'll discuss that the proposed law, because it's a very hitting point, and so many debates were there about the transfer of data from Pakistan to outside Pakistan. So under this improved law or the improved draft of the bill, there are three modes or the mechanism available to transfer data outside Pakistan. Firstly, it's the equal protection principle. If any other jurisdiction, foreign jurisdiction, offer the equal protection which is offered here in Pakistan, then data can be transferred. Then, of course, based on consent, if the data subject has given specific consent to transfer his data outside Pakistan, it can be transferred. And lastly, under a framework. Now, this is very important, because equal protection principle is there, consent principle is there. If these two things are not there, then based on a framework, personal data can be transferred from Pakistan to outside any other country. And this framework to transfer the personal data is also the responsibility of the National Commission to develop a framework. So I think I've taken some good time of all my dear colleagues, and thank you for listening me patiently. And now I would like to invite my colleague Letícia, and I believe she will be sharing PowerPoint presentation, and her topics of today's discussion will include main aspects or the main features of the Brazilian personal data protection law, and the powers and function of the Brazilian authority, which is entrusted to implement this law. And she will also touching upon some judicial decision about the liability. So over to Letícia, please.
Good afternoon and good evening. First of all, I'd like to give my compliments to the organization of this web conference, and also say that I'm very grateful to be here. I'm in fact delighted to be here and share this panel with so prestigious and expert colleagues. So thank you very much for to Clickaway creators. As Mr. Hasan mentioned, my task here today is to present, to give you an overview of the Brazilian regulation concerning data protection. So I will share a PowerPoint presentation with you just a moment. So Brazilian Data Protection Act. That's how we can call in English our legislation, our brand new legislation. I think that here in Brazil, we are in the middle of this path between Europe and Pakistan. We already have a law, we have the Brazilian Data Protection Act, but we still not have the experience that the European Union has. So let's begin from our constitution. Our constitution is from 1988, and it protects privacy. Privacy, the rights related to privacy are considered fundamental rights in Brazil. In our Article 5 from the Constitution, we have the individual fundamental rights, and there is express protection to privacy. Not to data protection, but we are already working on an amendment to make the data protection a fundamental right with an autonomy. There's a privacy right already, but there will be soon a fundamental right to data protection. We have several norms that are related to privacy, but I would stress the Internet Bill of Rights from 2014. It was the most complete one. And the other norms are also important, but they are sector-based, are sectoral. Then in 2018, it was created, our General Data Protection Act, that came into force 2 years later, last year in 2020. And that's the focus of my presentation here. The General Data Protection Act is broader than the Internet Bill of Rights. It's specific, it's multi-sector and specific for data protection. It was inspired by the GDPR. So being or not, Beatriz, a golden standard, it seems that it inspired the world as it was the inspiration for the draft from Pakistan too. And of course, despite the weaknesses that you mentioned, the GDPR, it's a very, very complete and important milestone for the whole world in terms of data protection. So our act, that we call in Portuguese, Lei Geral de Proteção de Dados. So the initials there, LGPD, are very famous nowadays in Brazil. What do we intend to reach with this legislation? This so difficult as it was remarked by Beatriz, to this difficult balance, fine balance between individual rights and economic development. Especially in these times we are of a data-driven society. There's no option. We have to share our data. We're not obliged, but there are most of the things, our conducts are, we need to share at some point our data. So the challenge is, that's what Brazil needed at that point to reach. How will our companies, our entities, both from public and private sectors, make an adequate use of personal data? So we needed, especially considering globalization, international commerce, we needed to reach this international level of data privacy. And that's the goal that inspired and lead all the works concerning the Brazilian Data Protection Act. So talking about the scope of application of this law, it refers to any practice that processes personal data. The same as that we see with the provisions of GDPR, our concern here is also the individual. So it's the personal data, the information about a natural person that the law intends to protect. Which data can we protect or shall we protect with the law? Almost any data. There are a few exceptions. So concerning journalism, art, some kind of research. In some situations, for instance, to balance with the freedom of expression, there are provisions appointing the exceptions. But in general, both online and offline, and of course online is more relevant nowadays, but online and offline data are protected by the law when applied to the personal data. So we don't have the scope here to protect company too. Also, an inspiration from GDPR, the law goes and acts beyond the geographic limits from Brazil. So we also borrow this inspiration for the extraterritorial application of LGPD, the initials in Portuguese, of course. So as I said, the personal data is a broad concept. The criteria here would be the possibility of identification of an individual, so a natural person. Other, if the data identifies or potentially identifies the individual. Because as we know, one of the main concerns of our society nowadays is because the entities that process data not only can know who we are, but also with the structured systems, with the cross of the information of all the systems, the big data companies, we can even know someone. We can know an individual behavior. We can even with metrics predict the behavior. So that's the main point here. Virtually any data, when processed this way, can not only identify, but also predict our conducts. So we could say today that with simple information as gender, age, and our smartphone tells Google, for instance, if we, at what time we wake up, if we go to gym, what do we like to eat, etc. So all this put together can influence a lot our lives, and that's why data protection becomes every day more and more important. The law also provides the concept of sensitive data that needs even more protection and higher standards of security, cybersecurity to be protected. The sensitive data would be any data that could lead to a discriminatory behavior from the entities and to cause potential harm to people using information related to health, sex life, race, gender, political opinions, genetic and biometric information. So also all these characteristics are also found in the Act, and our Data Protection Act.
Sorry to interrupt, Letícia. We are just only seeing your first slide. Are you moving the rest of the slides?
Oh, so, yes, I'm moving. I'm sorry. We still just see my first one?
Yeah, still it's the first one.
So stop sharing and try it again, okay?
Please.
And if I leave it like this?
It's fine. Now we are at slide 2 probably, so, yes.
So I will not put it in full screen, okay?
Fine.
So to process data, the subjects affected by this act have to have some legal grounds, legal base, and I stress 2 of them here. The consent, that's it's we could say that's very well. The data subject has to consent with the collecting and processing of the data, but not only. And that's the new aspect of the law in Brazil. The law provides also that it is a legal base to treat, to process data, the legitimate interests of the controller and the operator. Why? Because there are some activities that need this processing. So even though there's not a specific consent with this processing, the entity, the public or private entity, can treat and can process the data. For instance, if the employee, even if the employee don't give the authorization, the consent to his or her employer to send her or his data to an accountant or to an official entity of the government, the company may do it. Why? Because it is needed to comply with other regulations. It's an example of legitimate entity. Here too, we have limitations, and we have principles also provided by the law that have to be taken in consideration, have to be followed by the controller. Even with legitimate interest, there are limits. It must prove the necessity, the cybersecurity if needed, if it's online, and the non-discrimination practice. So we could sum up everything. Remember that our fundamental stone here, it's the mix or the relationship between transparency and accountability. And that is something very important here in Brazil, of course, all over the world, but as we are still beginners in dealing with all this legislation, it's not so simple and not so easy for all the business to practice this transparency and accountability. Especially if you look to the smaller business, small and medium business. Of course, if we're talking about big companies, international companies, they are much more used to this. But the law applies to every company, every business, every institution. So it's the legitimate interest and this relationship and the mandatory conduct of being transparent and accountable is something that we're still learning, that the companies and the business are still learning here. The law also provides some specific basic data subjects rights that I also put here in summarized way: the right to access data, to rectify data, to exclude, to know which data is there in the database of some business and how it's being treated. And that's a very important right here for our competition system, is the portability. The Brazilians here have the right to transfer their data from a company, from business to another, even if they are of the same sector. And this forced competition too. So in some way, it's a protection and it's a benefit for our market. On the other hand, there are some express duties provided by the law. The agents here are called, as in the GDPR too, the controller and the processor. It's controlador in Portuguese and operador. And they have the liability. We also can talk about the liability of the DPO, but I would stress here the controller and processor liability. there's a duty of, it's mandatory, the notification of the data breach. In Brazil, the most famous cases are related to the public sector. We had a very famous case concerning the data breach of our public health system some years ago, even before the law came into force. And today, I was talking about it before with my colleagues here. Today, we have a sad notice in our newspaper, at São Paulo's newspaper, that we have a site in Brazil that is selling our data. And the data is allegedly obtained in the public system from the tax authority, of course, breach of that tax authority, the retirement authority, the health authority, and this data from millions of Brazilians are being commercialized by the internet, and it's not the dark web. It's sad news for today. There's also the duty to mitigate damage. And this is in bold here in my presentation because the Brazilian law and the Brazilian judicial system is not so used to apply and to deal with mitigation of damage. It's not something very well known, not so practiced here. In some arbitrations, we see the discussion, especially because there is cross-cultural issues, sometimes you use even common law, but in our private law, the duty to mitigate damage is something that I could say that it's not so traditional. It's something new, but our Data Protection Act expressly provides this duty to mitigate damage. I don't need to talk about the data protection impact assessment because my colleague here, Beatriz, made a brilliant explanation about this, but you also have this provision in our law, and it is mandatory when the activity is already known as risky, and when not mandatory, can be requested by our data protection authority. The recording is also mandatory. The cybersecurity, of course, and although the agents of processing and treatment can share data, in many situations have to share data in order to exercise their operation, they have to consider third-party risk management. So the liability is not excluded by the conduct of a third party when the data is shared. So this, I think, that are the main aspects of our law. As I mentioned, it came into force last year, so we don't have much experience with it. Although we have this constitutional protection to privacy, although we have other norms that regulate data protection, but it's from last year, from the 2 years ago, but mainly from last year, that the Brazilian, not only our community that are already used to these issues, but what I think it's very important, Brazil is a huge country, and the law applies to the whole public and private sector. So it's a big challenge for us to have the implementation of the data protection. Should I go? So I go on, Mr. Hasan would like to make some questions, specific questions.
If your presentation ended, So thank you very much.
No, I will make some notes about the Data Protection Authority.
Yeah, please can you continue, because we are having a time slot. So if you can, a couple of minutes you can take to conclude your points, please.
Okay, so please let me know if I run out of time.
No, I'll do.
No, our Data Protection Authority is even newer than the law. It was created this year, and it's not fully operating yet. It's called Autoridade Nacional de Proteção de Dados, Data Protection. It's a National Data Protection Authority that is meant to be responsible for the supervision, to create a national policy, implement guidelines and good practice, apply penalties that would be notices and fines, and is responsible for the communication with all the agents. So we have, of course, the figure of the data protection officer that makes this bridge between ANPD and the agents, and also the data subjects. For some weeks ago, we have the creation of, we have the launch of the regulation of what we call here in Brazil, the disciplinary proceedings. So we didn't have yet a proceeding behalf the Data Protection Authority, and so we don't have applications of fines and notices yet. It's also something that we are about to learn. So coming to my final remarks. In Brazil, we have the challenge is to implement the culture of data compliance and understand, each business understand that it's an opportunity. It's a competitive advantage that one can have in the market. As I mentioned, the small business, in my view, are the ones who are having the more difficult to deal with it, because you have a lot of small business in Brazil. And even to simple implementation of the Brazilian Data Protection Act, it's not so easy, and it's not, and it's costly. Many times I can feel that the entrepreneurs think that it's expensive to implement, to have an advisor, to produce documents. So it's really a challenge here for us. The government, concerning especially the protection of consumers, are making efforts, Mr. Hasan, as you mentioned that you think it's a challenge for Pakistan. Our government is making efforts to create this awareness from our consumers. I share with you, unfortunately, in Portuguese, there's no translation, but there is a guide from our National Secretary of Consumer, explaining the population what we're talking about when we talk about the Data Protection Act, which are the rights, what is the authority, the national authority, and how it works, or how it will work. We have also the consumer code to support this, but of course the data protection law is much more complete and supplement the consumer code. Following this challenge, next year in January, the authority will start the first cycle of monitoring. So next year we'll see the results, and I would guess we'll be able to test what's working, what's not working, but we still don't have decisions coming from the authority. Yes, we do have jurisprudence and I'll also share with you a document in Portuguese. And you have this study it's very rich, but the population is still, the time lapse, I would say, is still very short, because we just have one year more or less of enforcement of the law. But we have this very, very well-conducted study about the decisions, the judicial decisions on liability and other issues concerning the Data Protection Act. And to end my presentation here, I leave you also a link to the translation from our data protection law to English. This one I have in English to share with you. So this would be my final remarks. I used to say that we are walking and we are getting better, but we also are taking baby steps and learning from the global community, learning from Europe, how to implement and how to deal with this great challenge that is data protection in the contemporary world. I leave you my contacts here, and I am available to any further questions or discussions with my colleagues and assistants. Thank you very much.
Thank you, Letícia. Very well planned presentation, I must say. You have started for your constitution and you tell salient features of the newly enforced Brazilian personal data protection law, and you discuss about the legal guides and the legal grounds and the principles. And I'm really happy to know that you are eager to learn from the Europe. Yes, because like in Pakistan and like in Brazil, because the subject matters are very new, the law is new, the authority is new. So of course, we'll be looking forward the mature, much mature jurisdiction in Europe to learn about these matters. And thank you again, and also thank you for your courtesy to share the English version of the law. Thank you. Now, moving forward, I would like to request Mr. Sébastien to have his discussion and his thought to share with us with all our panelists and other participants. And he will mainly be discussing the challenges in implementing the China privacy law. I suppose the law is introduced a few months back and will be introduced or implemented early next year, if I'm right. And he will compare the Chinese law with the GDPR and what happens when data incidents go wrong, I mean, data breaches. So over to Sébastien, please.
Thank you very much, Saeed. Well, I'm normally based in Singapore, where right now it's something like nearly midnight, but I'm currently traveling in Europe, hence why I'm not really dressed in a Singapore climate, but a bit colder place. So thank you for the kind introduction. So if I want to talk about China, I'm not going to talk about one data law. I'm not going to talk about two data laws. I'm going to talk about three data laws. Because you know the Chinese, one is never enough. So it started all in 2016, just like the GDPR. China passed its first data law called the Cybersecurity law. So it was more about basically making information infrastructure secure. Then this year, they passed the Data Security Law. They passed it in July. Then in November, they passed a new law, which is called basically the Data or Personal Information Protection Law, or PIPL, which is a kind of Chinese equivalent of GDPR. But there are major differences with GDPR that make the implementation quite challenging, to say the least. The first one is, the law became effective last month, 1st of November, but we still don't have all the implementation guidelines. So you have a law that's quite vague on some points, and you don't really have concrete implementation guidance. So sometimes you have to guess what the regulator wants you to do. And there are some aspects of the law that are not even known as of today. So for example, there's this idea of threshold. If you want to take personal data out of China, let's say if you transfer a lot of data, you're supposed to get a security certification from the regulator in China. Interestingly enough, the regulator in China for privacy is the same one as the one administering the internet. So when I said administering the internet, basically it's managing censorship. So you have a same regulator who, on one hand, manages data, and the other hand is supposed to enforce privacy law. So it's quite interesting to see how it's going to do that. And so the law says above a certain threshold, you need to get certification from the regulator. The issue is nobody knows what this threshold looks like. So you have lots of multinationals who right now don't know, like, do I need to get certified? Don't I need to get certified? And they don't know because there is no threshold definition. The second aspect is, as I mentioned, is you need to get security certified. The thing is, as of today, we don't know what this certification looks like. So you don't know what you need to do exactly. You're not sure about what aspects are going to, to be looked at, and you don't even know who is going to do it. Is it the regulator itself? Is it a third party? So you have all those challenges about, being basically PIPL compliant when there are so many aspects that are not basically known as of today. And to make things even more interesting, in Europe, you're lucky. You have a GDPR and that's it. If you look at the US, it's a bit like a birthday cake with like various parts. We call this a three-tier approach. You have some kind of sectoral law like HIPAA, for example. Then you would have something about a certain state, like California, for example, privacy law. Then you'd have something like just for children, for example. So let's say if you are a privacy person or lawyer in California and you work in the healthcare industry and you deal with minors' data, you have three laws that are just on top of each other. You have healthcare privacy law, you have children privacy law, you have California privacy law. Well, in China, we're going to basically have something like this. Yes, there is one national law, which is called the PIPL, but Beijing has already made it clear that there would be some kind of sectoral laws. Like, for example, you're in the automotive industry, you'll have automotive dedicated privacy regulation. You have a banking industry, you'd have banking dedicated privacy law. And on top of this, local governments will be able to have their own privacy law. So you could have a Beijing, for example, privacy law, you could have a Shanghai privacy law, and you would have to pay attention to all those privacy laws whenever, for example, you want to process data or send data overseas. So it makes things very, very complicated. And as of today, I mean, we've worked internally with our own legal department, we've worked externally with external legal counsels, and everybody has more questions than answers of today. Because there are just so many things that are not known yet. And because there is no case, basically, that has been, since the law became effective 1st of November, since you don't have any implementation guidelines, everybody is just looking at each other like, okay, what is my competitor doing? Like this, it's better to be wrong altogether, but to be right by yourself. So you have lots of basically wait and see attitude right now about how to implement China privacy law. Now, if I look at the differences between the China PIPL and the European GDPR, there is very big one major difference is GDPR applies to both basically private organizations and public organizations. In China, the focus is clearly on private organizations. There is not much said, for example, about measures that could limit what the state does with personal data. For example, in China, you have something that is called the social credit system. What does that mean? It means, for example, that let's say you want to cross, at a traffic light. Well, the traffic light is basically green for the cars, so it's red for you as a pedestrian. You shouldn't be allowed to cross, but you do decide to cross. And there is a CCTV at that point that catches you crossing the street when you shouldn't. It's going to lower your social credit score. Like, for example, in the future, if you want to apply for a visa to go overseas, the government could say, no, your social credit score is too low, you are not allowed to go overseas. So this is not touched basically by the PIPL regulation. So that's one difference. Another difference is the law as we understand it today has extraterritorial power. And one is very problematic, for example, for the banking industry. Let's say that you do wealth management. And one of your clients makes the headlines for the wrong reason, is involved in a high-profile criminal case. In all jurisdictions in the developed world, as soon as you have one client that makes the headlines, you need to file a report to the police locally. That's compulsory. That's part basically of anti-money laundering regulations. Based on our current understanding of China privacy law, you first have to ask Chinese authorities for the right to file a report to your local authorities. What happens if Beijing says, no, you can't file a report? Then you will be caught basically between Chinese privacy law and your local, AML laws. So which one, should prevail? As of today, nobody has the answer to this. And another difference as well is that usually, for example, if a company is fined by the regulator in Europe, it's just the company that's being fined. In China, you have personal responsibility that also is involved. Like, let's say, for example, I work for a Chinese tech company, and I have a laptop with me, I'm traveling, and I lose my laptop, let's say, at the airport. And my laptop was not encrypted, for example, and data of clients, personal data of client is leaked on the dark web, and it attracts the Chinese regulator's attention. Chinese regulator will say, well, as a company, you're fine because you've lost this laptop, and now there is all this personal data of your clients that are available on the dark web. It's even worse if your clients include basically minors below 14 in China. That's where the threshold is. Anything basically for children below 14 is considered as sensitive data. So the company is being fined, but the employee of a company and the CEO of this company could be held personally responsible by the Chinese regulator and could be personally fined as well. And then, for example, if you're, let's say, a foreign company in China that uses a massive amount of personal data, like, for example, you're an MNC that specializes in, consumer goods, and you have some kind of fidelity program. If you have any serious breach incident, it's not only the company that's at risk, it's the top management, and it's also maybe the employee that caused the problem in the first place. So that raises the question of how are you going to protect your employees in case there is a serious data breach. So that's another difference. And the last difference I'd like to mention is the PIPL in China has created several categories of personal data. So usually we have the sensitive data and then we have personal data. But based on Chinese data laws, of course you have sensitive data. You have something called kind of national core data. So it's data that if it's revealed or breached, it could endanger national security. But there is no real definition of it. So nobody knows, let's say in case of data breach under this new privacy law, like how will the regulator look at the breach? What will happen? Will it decide that it's normal personal data? Will it decide it's sensitive data? Will it decide it's kind of national core security data? So it's another difference with the GDPR is we don't have a clear vision of how things are now. Now, I will conclude by talking about some case studies to show you how the Chinese regulator looks at things differently compared to GDPR. If you look at GDPR fines, the largest one, basically, most of it are related to data breaches. Like, for example, if you look at Marriott, somebody hacked into the reservation system, or let's say Cathay Pacific, which is a Hong Kong-based airline, but there had a data hack, and the data of thousands of UK citizens were exposed, and basically they were fined by the regulator for not having security strong enough. Now, even though in the case of China, there's been no data breach that does fall under this law because this law is so recent, we have one very good example of what might happen even without any data breach. In the US, everybody knows about Uber, basically, which is a ride-hailing company that uses personal data a lot. In China, its competitor is called Didi. And what happened to Didi? They never had a data breach, but they did something that really irritated the Chinese authorities. They decided to get publicly listed in New York, despite basically Beijing saying, and the regulators saying, no, we think this creates a national security risk because, let's say, for example, foreign authorities could have access to personal data of millions of Chinese citizens. Because Didi is used by millions, basically, of customers in China. So Beijing told Didi, no, we strongly advise you not to get listed in the US. Didi went ahead. What happened? They got fined the first time by the regulator. They were forbidden to sign up new clients, basically, through their app. Their app could no longer be installed on devices. There was also talk of having a third party managing Didi's personal data. So imagine what that means. It means that, for example, let's say I'm a multinational, and I have to entrust all the personal data of my customers to a third party. And this third party could be government linked or could be independent. And this third party would be able to do whatever they want with the personal data of my own customers, and I have zero control over it. I mean, that's something that I've never heard of from the GDPR or any other privacy law in the world. And in the end, what happened is Didi is going to get delisted from the New York Stock Exchange because the pressure from the regulator is just too strong. And Didi, I insist, I never had a data security breach or a data-related incident. What triggered this was the fear that foreign authorities could get access to the personal data of millions of Chinese citizens, but without it happening. So Didi was punished for something that might happen in the future, but that has not happened as of today. And I think that's a major difference when you look at case studies between GDPR and China. In Europe, you get fined for something that has happened. In China, you can get fined for something that has not happened yet. And that's how I would conclude this brief, basically, introduction of China privacy law. Thank you.
Thank you, Sébastien. Very insightful information. In particular, you have a very logical explanation of the difference between GDPR and the China privacy law, and especially these case studies. So you have explained all these things in a very meaningful way. So once again, thank you. And now I will like to request our last speaker of today's session, Syed and Belal, to take his time to discuss his ideas and his points. And just to briefly introduce him, he'll be talking about the recent data breaches in the MENA region, Middle East and North Africa region, impact of the data breach on the critical infrastructure, and lastly, how to protect data, continuous adaptive risk and trust assessment. So over to Belal, please.
Thank you, Saeed. I think by this time, all the panelists already discussed in detail GDPR and privacy. And again, it's a pleasure actually being part of this panel. Thanks to LexTalk as well. So with that said, actually, like Saeed said, I would like to cover the recent data breaches in the MENA region, and actually what the impact is when the data breach happens on the critical infrastructure like oil and gas or power or utilities. My job responsibility includes securing the critical infrastructure, and one of the reason I chose or I decided to do so because whenever something happens, some attack happens on the critical infrastructure, it has direct impact on people. People may lose their life because there can be fire, there can be poisonous gas leaked. It will have an impact on the environment, and at the same time, the financial. I would say, definitely the economy of the country also will be impacted because in Middle East, actually, we rely on oil and gas only. Mid this year, I would start with one of the recent data breach. Mid this year in July 2021, one of the largest Middle Eastern oil and gas organizations, Saudi Aramco, actually confirmed that the data has been leaked. And the data included more than 6 refineries critical data that includes, but not limited to, like drawings, architecture, system design, and everything. The size of the data was more than 1 terabyte. And here's the surprising thing. When it was leaked, they said anyone who would like to download needs to pay $5 million. And if you'd like to download and delete the data, then you have to pay $50 million. Meaning that, of course, those $50 million offer was to Saudi Aramco. So, they wanted, if you want, that's like kind of ransom. You just get the data and we'll be deleting it. It was not disclosed how the data was leaked actually, but it was via one of the third party or on the vendors. That's why I think we already covered about supply chain management. So What's the impact of the data breach on the critical infrastructure? There is a reason behind asking for $5 million. It takes years to get details architecture. We know what happens in Ukraine power grid, right? It was a successful planned attack. They attacked during Christmas, and the second attack was automated. So anyone with those data can cause actually maximum damage. Attackers should know the criticality of the assets and can actually conduct a successful planned attack. The other consequences would be like CEOs would be against the CISO, because CEO actually expect the CISO to be, securing his or her network. The brand image will be impacted. Loss of customers, loss of sales is another byproduct. Unexpected expenses. So either the company will end up paying ransom, or actually they have to secure or update the system so that the data that was leaked won't be actually usable anymore. There will be, of course, less attractive to new employees, and there will be legal penalties. I'm sure everyone has already covered that part. How to protect the data? I would say continuous adaptive risk and trust assessment. While doing the risk assessment, we have to consider all the factors: threat, vulnerability, control gaps, and all of them. The other things are like, supply chain management. Like I shared earlier, the data was leaked by one of the vendor. We shouldn't be relaxed after handing over the data or after signing an NDA with the third party or vendor that yes, our data is safe there. We want to question our vendor or third party or supply chain, actually how we are managing our data. What would happen if the data gets leaked? Will you pay the fine? Will you ensure that our data is secure with you, or will you change the system or design of our network? With that said, I would say, the goal would be to be resilient. How we can do that? We need to know our inventory. We need to know what you have. We need to know what we implemented. We need to know where the data are located. We need to do a vulnerability assessment. We need to identify our weaknesses. Every time the ICS-CERT or vulnerability or National Vulnerability Database, they release vulnerability information. So we need to ensure we know our vulnerabilities before actually the potential attackers, get to know about them. We need to do threat assessment. We need to know who is actually potentially targeting us, or we are in which group, so that we can plan accordingly. We need to do proper change management. Anytime some changes happened in our network, we need to identify, was that a legitimate change or that was done by some unauthorized hackers. We need to regularly take backup and test our backup, considering recovery time and recovery point objectives. Other thing is I noticed in critical infrastructure, and I'm sure it's applicable to banking and other industries as well, is the escalation of privilege. Someone joined as a trainee, with time, he or she became engineer or maybe became manager or became director. So with time, his roles or her role got changed, responsibilities got changed, but the access he or she got was not actually removed. So we need to continuously do roles and responsibility assessment, because with time, if you keep on adding more privilege or more accessibility to someone, and that particular account got hacked, then the impact would be maximum. So with that said, I would welcome if there is any question. I'm at the end of my presentation. Thank you.
Thank you, Syed. You have explained in a very elaborative way, especially how to protect a attack. And what I can see from your discussions, it is important for all the data controllers, or say in simple, but the companies, to get themselves prepared for something. So you have to get preparedness is important, so we can have a good preparedness for any potential cyber attack. So with all that, I would like to thank all our learned colleagues and the speakers who spared their time to have this afternoon to discuss their professional ideas and their knowledge, share with all other participants. And before getting to Sagar, so he can put some question and answer by our audience, I would just like to say that there a few days back, I just concluded a short course on data privacy from the London School of Economics. And there we learned that about more than 80 jurisdictions have followed the GDPR framework. So we can say that GDPR is now considered as a global standard for regarding personal data protection framework. So, but I believe that in coming years, because of consistency in legal principles, I believe some international organization like WTO or the UNCTAD may frame a uniform or the model law so that that will be applicable across the globe similarly. Secondly, a new concept is coming. It's important for the legal practitioner, as we all are, or most of us are the legal practitioners, that now the researchers and the scholars are propelling a new idea, a duality of data. Initially, we have discussed that the law, the data is a right-based. I am an individual, I'm a data subject, I have got some rights. Now the duality of the data concept says, you have a right, I have a right, but I have the ownership of data. And based on this ownership thing, I can license it to the third parties on a copyright model. So I can allow my personal data to use by third party through a licensing arrangement under a copyright model. So this is a new concept coming down. So we as a practitioner, legal practitioner, should keep ourselves updated from these new upcoming trends, so that we are good to advise our clients in these situations when the concept duality of data will hold its roots.
I guess
and if you have
network issue. Oh yeah, we have Mr. Khan back. I guess Mr. Khan, we had a network issue with you in between. But thank you very much, all the panelists for such a beautiful session. I mean, I'll be honest with you, I'll not lie. For not even for a single second, I was I was out of this chair. I was just sitting right here. It was a really insightful session for a guy like me as well. We have a lot of questions here, and I want we cannot of course ask all the questions because we have already surpassed the time limit for like 6 minutes, but we'll try to cover it like within 5 to 6 minutes. And I have one more question of mine, so I want that question to be kept as a showstopper. That's an ironic question that I have. Anyways, talking about the questions that we have from the audience. So talking about the first one, we have it from Samantha D'Souza. That's from Sri Lanka. And the question is, what's the most comprehensive legislation on privacy? Now, who's picking that up?
With permission to Beatriz, because
none of them.
Because she put a question that whether it's the golden rule or not, but as of now, because the advancement of the law, we can safely say that a comprehensive law at the moment, we can say GDPR of EU, we can say that is a comprehensive law, though my colleagues have said it is not covered all aspects, but it is the most modern and most engaging piece of legislation over a framework. Beatriz, you would like to say something more?
Yeah, I do agree with you. I think that now we are in two types of privacy frameworks or models. Those data protection laws who are still working on amending to follow up the GDPR approach. Yeah, that data protection laws follow up the old directive. So that's why we are still seeing many data protection laws on which consent, yeah. For instance, for giving you an example, it's critical. And of course, those countries which are really following up the GDPR. So, but my point of which is the most comprehensive, I would say none of them. I'm still having my same view. I mean, it's a very good standard point of view if you would say like this. But it is enough? No.
No, that's a fair answer to this. I guess everyone would agree to that. We have another question from Ethiopia. That's with Edis Gemechu. And I would like to throw this question to Sébastien, because he is very good with the examples. So I want him to be clear on this. It's a very simple question, I believe. Yet a difficult one. What is the limit to privacy rights? That's the question of Mr. Gamanchu.
Sorry, what's the limit to privacy rights?
What is the limit to privacy rights?
Well, the limit currently is whenever you infringe upon somebody else's privacy, then that's the limit. You shouldn't do that. Now, the question is, there is no clear definition of what infringing upon other people's privacy necessarily is. And if you look at GDPR, which is not perfect, but by far the most comprehensive, it's quite clear. If you look at other privacy laws like China, for example, it's not so clear. So I would say it depends on where you are in the world and how people define not only privacy, but also basically infringing upon.
All right. Okay. We have another question from United States. With the question is by Zulfikar Syed, and the question is, what are the most appropriate remedy for the breach of data? I see we have very open-ended questions here for the panelists.
So appropriate remedy, because it's a very, in fact, it's a very interesting question for one reason, because in most of the laws, including the proposed law in Pakistan and also in GDPR, the remedy to data subject or the renewal is not there. So if a company, data controller, or an employee, as Sébastien has said, that an employee of a company has got some breach of the data, the company can be fined by the regulatory authority, and also the individual or the person, national person, employee of the company can also be penalized. But the set of this framework do not provide a remedial action in terms of monetary terms to a data subject. In talking within the Pakistan perspective, if a data subject's privacy is leaked or breached, he can have some rights under some other civil laws. But the data protection law does not give him a financial remedy, except for that to stop the breach. The maximum, the non-financial remedies there, that the relevant data protection authority or the court will direct the hacker or the infringer that just to stop this infringement.
Great. I guess Syed also had something to say about it. Yeah, please say.
Yeah, I was going to say, how to prevent it, actually, how to prevent the data breach. If you are not posting any information on the social media, then no one would know about it. At the same time, the government, they're doing everything possible actually to protect your data. So, that part, let's leave to the government. Like for European, I'm sure everyone already covered GDPR and other stuff. So I'm just going to say that, if you're posting something on the social media, don't expect that, that will be, secure. And later on, if someone asks why my data is hacked or leaked, well, you are responsible for it.
All right, and I can see other questions that has been already covered in the discussion that we all the panelists just did. I have another question. As I said, it's a showstopper question from my end. I recently had a case study of Mr. Hasan, the founder of WikiLeaks. So the question that I have, I mean, I'm not sure whether this makes sense to you guys or not, but still. So WikiLeaks is an organization where, you basically put the data that you sort of, cannot put anywhere, or, it basically makes it sort of readable to the audience, and it brings a lot of revolution. And it has brought a lot of revolution in states and in different places in Europe, and, so on and so forth. The study says that maximum data that is there is sort of a stolen data. I mean, the hackers went up to the official profiles in the CIA, they broke down and got the data, and then, they just leaked the data. That was precisely a sort of a very disturbing one, which was supposed to be seen by the audience, by the countrymen and the countrywomen of the respected country. In that case, do we say that data breach or hacking of these sort of things is really wrong, or is it sometimes okay to do it? I mean, when it comes to the welfare of the human beings that are right there in the same country.
I would like to first comment on your question, and then I will welcome my colleagues. You know, the right of privacy has got its roots since 1948, when the UN Declaration of Human Rights, and this, I think it's Article 12 says about the privacy of the individuals. So in any way, I would say, just speaking legally, the privacy or the breach of privacy or the infringement of privacy rights that started since back 1948 are a legal, I say, crime or offense when it is breached. So no matter it is traded in dark web or the WikiLeaks or institution like this, there is a breach of the fundamental right. And the fundamental right, just for your knowledge, that to your understanding, fundamental right is a right which cannot be eliminated, which cannot be taken away from the individual. So by birth, a national person got a fundamental right that his personal data or his privacy, his or her privacy will be protected. So whenever it is breached, it's a breach of law. So there is no excuse. No matters how it works. We all seen daily WikiLeaks published on the newspapers, the printed material, and the social media. But yes, it is a convention and a breach of a law.
Right. So I'd also love to have Sébastien and Beatriz and Syed. I mean, everyone's view on this question to sum up the session on this.
Well, I think one of the challenges is law versus ethics or law versus moral. You know, there is what the law says, you take somebody else's personal data, that's a breach, that's illegal. At the same time, if the personal data reveals that this person was doing something very wrong, then one hand it might be illegal, but on the other hand, this is ethical to reveal that somebody is doing something wrong. So it's a very, very old debate about, you know, the law versus the ethics. Usually the law always prevails, but it's not because something is necessarily legal, but it's also ethical. Mm-hmm. So this is more a kind of philosophical description, but I'd like to broaden it. It's not just the WikiLeaks. Look at the Pandora Papers recently, you know?
It's the same.
Yeah, it's exactly the same.
We have to have another web conference to discuss about the Pandora Papers.
It's exactly the same. So would you say that, you know, Pandora Papers are illegal? Are they unethical? Or, you know, it's very, very different. It's sometimes people do wrong things with the right intention. And you could say Pandora Papers or WikiLeaks is people want to make the world a better place, but by hacking into somebody's, you know, personal data.
Mm-hmm, mm-hmm, mm-hmm. All right, so we can see Leticia's hand is there. So over to you, Leticia.
Thank you, Sagar. I just want to make a counterpoint to Mr. Hasan's opinion. He's right, it's illegal, but I think that you have to consider also if the information leaked should always have been public. Sometimes it was hidden and the transparency principle was not respected. So if the information should always have been public, I think that's another approach.
All right, over to you, Beatriz.
Well, I don't really need anything else to add. I think that all my panelists here have already explained, right? I think all of them are right. I think that it also has to be a balance.
Makes sense. Over to you, Saeed.
Yep, same here. I think everyone has already covered it, but to me, anything that is accessed illegally or leaked illegally is actually wrong. And it's just my opinion. You know, I was just thinking if someone hacked and leaked some data, how authentic that data could be. I mean, even they might have changed some of the contents and then post it, right? How can you trust them as well?
No, I mean, of course, I mean, as I said, so we have to have another web conference, rather a conference of 2 days or 4 days to have a discussion around the WikiLeaks and Pandora Papers and all these ethics versus legal debate, as Mr. Sébastien said. So having said that, I guess my question was worth it. We all incorporated in that. So once again, thank you very much, everyone, for joining us for the session. Special thanks to all the panelists who joined us, and of course Mr. Khan, who at last minute accepted for being the moderator for the session. I really appreciate it, Mr. Khan, and we all do. Thank you very much. It was a great, bond over towards the entire conference. And for our viewers, thank you very much for joining us for the session, for your questions. I understand we have more questions there. What we'll try to do here is we'll put these questions in the LinkedIn, comments. You can put it right there in the YouTube comments. The video is already on live in the session, and I guess our panelists will have an active view on all of that, and they will be reverting back to your questions every now and then. So with that note, I again appreciate everyone joining us for the session, and stay tuned to LexTalk World for web conferences like this, and see you on the other side. Thank you very much. Thank you for joining.